Imagine the cops show up at your house demanding that your juvenile surrender himself to be taken to the court for a warrant. What do? Do you trust the cops and you have him walk outside, or do you do what the person in our video today did and put on a masterclass of calling bluffs and making cops look like morons? Dumbness is scary, but it's also entertaining. Let's talk about it. What's up, you guys? Welcome back to Southern Draw Law. My name is James White, criminal defense attorney, former prosecutor, former police officer. So this video was circulating the interwebs, and I saw it on Facebook. I've seen it on Instagram. I've seen it on YouTube, all different creators. So I really don't know who to give credit for it, but it purports to show a Texas Ranger being allegedly threatened with false arrest. Take notice of the fact that the person says that they live in Texas and that they're familiar with the law, but nothing to suggest that this person is in law enforcement or is a Texas Ranger. So I have no way of knowing, but the guy handled himself really well. And it's really a good example of what a person should do if the police show up at their house trying to do a knock and talk or trying to talk them into allowing them to enter the home. So I don't know who to give credit for the video to, but it is a good video. It's supposed to have been in the last couple weeks, and it's supposed to be in Fairfax County, Virginia somewhere. So without further ado, we'll just watch the video, we'll check it out, and then we'll come back and talk about a couple things, because regardless of where it is or who it is, we still have some cool stuff we can talk about as it relates to the law. Let's check it out.
So your son, we have a warrant for your son.
Let me see it.
We do not have it in hand.
Well, then you do not have a warrant.
I'm sorry?
Then you do not have a warrant. What are your officers' names? Give me your names and badge numbers, please. Names and badge numbers.
I'm Sergeant Ando,
Badge number.
3841.
Your name.
Boya, 4468.
And your name.
Brown, 4515.
You say you're here with a warrant, but then you say you don't have a warrant.
The paperwork's at the warrant.
No can do. I'm familiar with the law. You guys were here the other day, correct?
We weren't, no.
Okay.
We weren't here.
Well, my wife was, and she has 2 law degrees. And as stated, this will be forwarded to her daughter, who's a political appointee by the current administration at the Department of Justice in Washington. A lot of people don't know that. Go get the warrant and then come back. You think that he's coming out there? I know my rights. I can quote constitutional law all day long. I may have long hair, but I wouldn't let it fool me. I wouldn't let it fool you.
Well, sir, we're not trying to play any tricks on you, okay? There is paperwork for him to go up to the intake officer to get that paperwork signed, okay?
Yeah, well then I will wait until it's signed.
Well, he's got to come up there.
Doesn't work that way, pal. You know that and I know that. I know the law. I know the law.
So he needs to be present for the paperwork to be signed.
That ain't going to happen, pal.
It's getting signed.
I have an attorney that, listen, I have an attorney in this area.
Real quick, sir, so we can have a conversation back and forth.
Go ahead. Go ahead.
Right? For the paperwork to be signed, he needs to be present so it can be served on him. So he can.
Will not happen. That's not how it works.
Okay. How does it work?
You tell me.
I just did.
No. Unless there's a warrant, we're in the curtilage of our home, and according to Collins v. Virginia 2018, we do not have to come out. I can quote knock and talk. I can quote constitutional law. I can quote case law, judicial precedent, whichever route you want to go, but he will not come out. Sorry. No can do.
You realize that we're going to come back.
That's fine.
We go to meet him at a school. We go to your job. You know what I mean? It's
Hey, listen, are you trying to threaten me?
No, I'm just telling you that he has to have the paperwork served on him.
Well, then do it.
All right, you have a day in court, okay? We don't know.
Hey, listen, you're barking up the wrong tree, okay? I know law. I'm just going to leave it at that. And what you're saying is, puts a smile on my face because it tells me that you guys don't have anything. If you have a warrant for his arrest, bring it.
Okay, he's just explaining to you. He just explained
It's not going to happen. I'm telling you, it's not going to happen.
now. It'll be simple. We go up there. We take care of some paperwork.
No, you're not coming in the home. Without a warrant, you will not enter my home. Where are you guys out of? Is it Franconia? Okay. Then you don't have far of a drive to go and get the paperwork signed and brought over.
It's already signed.
Well, then why didn't you bring it?
It's already signed. It's on our warrant deck. It's on Fairfax.
You guys aren't making any sense. With all respect, you're not making any sense.
That's how our policies are, sir. When the warrant
That's fine. But law says unless you bring a warrant, he will not go. And then you were talking about the workplace and different things. I perceive that as
what I'm saying is you can handle it right now.
handle what right now?
We have to keep looking, meeting you at different places. That's what I'm.
What do you mean meeting us at different places? You just showed up here. This is where he lives. It ain't going to work. I'm telling you now. It will not work. I live in Texas, so I'm familiar with Texas law, okay? I'm not licensed here, but I have attorney friends here, and I have one that's going to be representing him in juvenile law. And I just got off the phone talking with her moments ago. So I suggest that you guys go and get the warrant the way that it's supposed to be done, and then come back. Otherwise, see, look, I'll tell you this, in Texas, it's like here. I understand that. I'm not stupid. If you had a warrant, you'd be coming in and showing it, and he'd be coming out. I am just floored at the position that you're standing here saying that you want him to come there and sign something, and you have a warrant, but you have no warrant on you. But you want me to bring him out to you.
Okay, so when the paperwork, right? When we obtain a warrant, okay, juvenile or adult, it gets signed by a magistrate. If I may, quick, okay? It already gets signed, which means it's already valid, which means your son is wanted, okay? All that we're saying is that we take him down to serve the paperwork, to serve it on him.
It's not going to happen.
An issue.
Will not happen. If you want a civil rights lawsuit against the respondent being Fairfax County, good luck.
You want to call up the warrant?
No, I'm not going to call anybody. That's your job.
We already did. We already did.
Well, then go get it. We're at a stalemate. If you guys had something, you'd already be coming in. If there was a state of exigency, you'd be coming through the door. If I gave you permission, you'd come through the door. If you had a warrant, you'd come through the door. You don't have either of the three, any of the three. I hope not. Because I'm already have somebody that's going to be filing a civil rights lawsuit against the department. The respondent will be the county, of course.
All right, well, we'll do that.
That's what I thought. It's exactly what I thought.
All right, we'll see you, bud.
You bet.
Okay, so that was a lot of fun to watch, and I thoroughly enjoyed the fact that these guys were completely tongue-tied and had no idea what to do, what to say to this guy. But there are laws and cases that govern this sort of stuff, so we should talk about how it actually works and see whether you guys think they actually had a warrant or whether they were bluffing. I personally think they were bluffing, and I'll explain why. I think they were not necessarily bluffing. I think they were being lazy. But the first thing I want to address is that the homeowner in the video got the Collins versus Virginia reference incorrect. It's correct in its principle, but it's incorrect in its application to this particular situation. And the reason that I say that is that Collins was a case where the police entered the curtilage of someone's property to basically check the VIN number of a motorcycle that they believed was stolen. So they entered the curtilage, they removed a cover off the motorcycle to check the VIN to see whether it was a motorcycle they were looking for. And the court said you can't do that without a warrant, even if you have probable cause to believe the motorcycle was stolen. So where it seems like Collins might apply to the situation, it actually doesn't, because Collins was about searching for evidence of a crime, not arresting someone inside their home. So we know from previous videos that there are really two primary cases that guide arresting people inside of a residence, right? So we have the Payton versus New York case, and then we have Stegall, which are both United States Supreme Court cases. So just to make sure we all understand, a person's home, including their curtilage, is the most protected place in constitutional jurisprudence in the United States. The courts have routinely said that in order to arrest a person inside a residence, the arresting officer either needs a warrant or one of very few narrow exceptions like consent, exigent circumstances, or hot pursuit. In Payton versus New York, the Supreme Court said that even for a felony, the cops had to have a warrant in order to arrest a person inside their home. We discussed this at length in the Natasha Lopez case. And another case we discussed in the Natasha Lopez case was stay galled. And in that case, you may remember that the court said that if you're going to arrest someone in the home of someone else, a third party, then you need a search warrant for the home of the third party in order to enter their home to search for the wanted person, in addition to having the legal authority to arrest the person that you're looking for in the first place. Now, that's a key point of distinction. Note that if the police are arresting a wanted person inside the home of a third party, they need a search warrant, according to stay galled. However, they do not have to have an arrest warrant for the person. They only need an arrest warrant when arresting a person in their own home. So if they have a search warrant for the third-party residence, then they can make a warrantless arrest if the factual circumstances would have provided the authority for the officers to make a warrantless arrest of the person they were looking for. So an easy example would be, again, the Natasha Lopez case. Remember that the officer was looking for Natasha's son because he alleged that Mr. Helms had fled from him on a motorcycle a few days prior. Now, when we go through the IA interview, I'll point out why Corporal Mills is an idiot and he didn't have PC for the arrest in the first place, but let's assume for a second that he did. Let's assume that he tried to stop the motorcycle, he recognized Mr. Helms, he knew his identity, and then Mr. Helms ran on the motorcycle. And then assume that he developed information that Mr. Helms was hiding out at his mom's house in order to avoid capture. Had he possessed the legal authority to make a warrantless arrest of Mr. Helms, and had he applied for a search warrant prior to breaking into Natasha's house to look for Mr. Helms at Natasha's house, the arrest would have been legal so long as it would have been legal for him to arrest Mr. Helms without a warrant. Now, obviously the person in question here is at their residence, so stay galled does not apply. We're focused on Payton versus New York. But we also learned during this back and forth between the police that the person wanted here is a juvenile. So then the question becomes, does the fact that this person is a juvenile change anything legally speaking? And the answer, like everything else in the law, is it depends. It largely depends on the state that the person's in and the juvenile processing procedures for that state. Now, this is supposedly in Fairfax, Virginia. I live in Tennessee. We're neighboring states, but we do things in a way that is pretty much diametrically opposed. In Tennessee, we do not allow juveniles to be securely detained except in very rare cases. There is a statutory mandate in Tennessee that prosecution of juveniles is aimed towards treatment and rehabilitation and is not punitive, whereas the aim of the adult correction system is correction or punishment. So we don't use pretrial detention for juveniles in Tennessee like we do for adults. The basic requirement for actually holding a juvenile in secure detention in Tennessee is that there is a threat of serious bodily injury or death either to the juvenile offender or someone else. That's an oversimplification and there's more nuance to it, but I'm not trying to teach you Tennessee juvenile law. I'm just trying to lay out nuance for context. So if a juvenile commits a crime, or what we call a delinquent or unruly offense in Tennessee, and it's not eligible for detention. So it's not statutorily enumerated as a detainable offense, or it's not anything that would be like serious bodily injury or death to anybody. The officer would then file what we call a juvenile petition, and then the juvenile court uses youth services officers, otherwise known as juvenile probation officers, to do what they call an intake. In most places in Tennessee, it takes about 8 weeks or more after the incident giving rise to the petition itself for a juvenile to be called in for intake for any offense that would not allow pretrial detention. So a kid gets in a fight at school, the SRO writes a petition. 8 or so weeks later, the kid gets a letter in the mail or a call from the court requesting that they come in for intake. At intake, the youth services officer will then determine whether the offenses and the child's history with the court warrants either them going to the court or they can offer what's called an informal adjustment. And then they'll either give them a summons to go to court or they'll tell them the requirements in order to discharge the informal adjustment. If they fail to show up for intake, or if they fail to show up for the summons if they're supposed to be in court, then a judge will issue a detention order only for the purposes of getting them to intake. Now, that works like an arrest warrant, okay? So that has the same legal authority. If the officer has an arrest warrant, they can go inside the home and they can arrest the juvenile, whether or not the parent consents. Now, Virginia does pretty much the opposite. In Virginia, the officer responds to whatever incident is going on. The officer prepares a complaint for a juvenile delinquency allegation, but the difference is the officers can take that complaint directly to a juvenile intake officer, which is pretty much 24/7 in most places. And then the intake officer decides whether to immediately issue a detention order or issue a summons, or divert the case like an informal adjustment, or refuse the complaint entirely because it lacks probable cause or whatever. If the intake officer issues a detention order in Virginia, it is immediately sent to the magistrate or judge for a signature, and once it's signed, it becomes an arrest warrant under Virginia law. So police can execute that order immediately. They don't have to wait weeks to get letters or calls. There's no voluntary please show up. They go to your house, and they have the authority, if they have that detention order, to treat it just like they have an arrest warrant for an adult, and they can go in your house and take the child regardless of whether or not you decide to comply. But they do have to do a couple things, like they have to allow you to have an opportunity to comply and all that stuff. So in my opinion, they probably did not yet have a detention order in this case, because if they had already had a detention order, they would have had basically the equivalent of an arrest warrant under Virginia law. They wouldn't be standing at this guy's door saying, hey, bring this kid out here so we can take him up because he's got to sign the paperwork. He doesn't have to sign the paperwork unless they're trying to cut corners. All they have to do is submit their paperwork and let the juvenile intake officer decide whether they're going to issue a detention order or an arrest warrant, right? That's not what happened, obviously. So the way that they conducted themselves is evidence to me that they probably didn't have the detention order, because if they did, the conversation would have been a whole lot more like, hey, we have a detention order for your son. Please step aside. We're going to be coming into your residence. They would not be standing at the door, negotiating, threatening future visits at somebody's job, explaining that he needs to sign something, asking for the child to come out voluntarily, all that stuff. None of that behavior aligns with police officers who have a legal arrest warrant that they could execute whether or not you are compliant. Now, a very important note, you should always ask to see the arrest warrant, but maybe not for the reason that you think. There is no general constitutional right. And outside of a couple of states who might have made it statutory, I don't know of any, but there might have been. California does stuff like this sometimes. There is no general requirement that police show a person a copy of either an arrest or a search warrant prior to executing that warrant. In order for a warrant to be lawfully executed, all that has to happen is that the warrant exists, that it be signed by a neutral and detached magistrate, and that the police have actual knowledge of it. But the value in asking for it is that you get to do what they do to us. You get to determine, based on the way they behave, how you can judge or assess their credibility and truthfulness by watching whether they melt down or do what these guys did and just get stuck and freeze and have no idea how to respond. This case provides a perfect example of that. But you should know that they don't actually have to show it to you, right? Just the same as, I'm asking for a supervisor on the side of the road. Okay, their policy might say they're supposed to, but there's no law that says they have to do that. So you should know what the limits are for what you're asking for, what they have to do and what they don't have to do, so you can make decisions as to how you're going to conduct yourself and where you're going to draw your lines in the sand. In closing, it's my opinion that one of two things happened in this case. Either A, the officers were trying to be lazy and shortcut the process by trying to intimidate people into voluntary intake compliance because they didn't want to go do whatever steps they needed to do in order to get the actual detention order. Or B, the officers do not understand that a detention order is the same as an arrest warrant, and they don't understand the authority that comes along with having it, or that it works the same as an arrest warrant, and that they don't need the actual homeowner's compliance, and that it's just the same as having a warrant for somebody, and they could have actually forced entry if the person refused. Now, importantly, either of those explanations could have led to this mouth-breathing confusion that we saw as they attempted to assemble their collective IQs together in hopes that someone would come up with a good idea, and that's likely the reason we all thought we saw smoke coming out of their ears, right? But regardless of which explanation for their behavior we get, neither are good. If they were just trying to shortcut, that means that they are being lazy and that they knew what they were supposed to do, but they were, just trying to keep from doing it. A lot of times people will work harder to keep from doing what they're supposed to do than they'd have to do just to do it. And so they try to intimidate citizens into abandoning their rights, and that's not what we paid them to do, right? If that isn't the case and they weren't being lazy and they just didn't know, that's just as bad, because they should have enough sense to anticipate that someone might not want to do what they're asking and expect them to produce evidence of the warrant. It's important to understand, just like it's important for you, the citizen, to understand that you can't force them to do certain things. It's equally important that they understand the scope of their lawful authority before they try to take enforcement action. Now, sometimes scenes unfold and timing's an issue and you don't have time, but if you plan to go do a knock and talk, you should probably have a good idea of how you're going to handle the scenario before you get stuck at the bottom of this person's stairs in what is a death funnel while you're standing around like a gaggle of mouth-breathing clowns with your brain smoking trying to gather oxygen. And if we just expound on that idea just a little bit, what we saw here is that one of these parties was prepared for this interaction, and the cops were not associated with that party. As we discussed a little bit ago, the homeowner was not entitled to see the warrant. He may or may not have known that, but that doesn't matter for the purposes of our discussion. It's just an example of how powerful it can be to not just know the scope of what you can do, but also know the scope of what the cops can do. Because if you really think about it, what he did is no different than what the cops were trying to do to him and what cops do to people routinely. I mean, they were at his house. They were trying to make him believe that he had some obligation to do something that he didn't actually have an obligation to do. And where they screwed up is they didn't have a plan or any sort of fundamental understanding of what they were allowed to do if he said no. And so he may have incorrectly thought that they had to show him the warrant, or he might have just asked to see the warrant to gauge whether or not they were full of shit. And guess what? They failed whatever test he was throwing at him. So just like when a cop does a knock and talk or tries to get your ID on the street, he very well may know that he doesn't have the authority to make you do what he's trying to get you to think he has the authority to make you do, but he's going to gauge his next steps based on what you do and how you respond to the inquiry. So remember, the person who generally prevails in any sort of negotiation is the person who is armed with the most information and generally cares less about the outcome. So I don't say cares less as in like you don't care, but the person who's more subservient to their emotions in the moment is the person who's going to make mistakes. I always say, like, when it comes to buying something, that the person who cares the least is the person who wins every negotiation. Because if I want a car, but I want that car less than the person who wants to sell me the car, then I'm going to win this negotiation because I'm going to get a better deal because they want to sell it more than I want to buy it. Okay, so I don't mean like the person who cares the least wins the negotiation here, but the person who's less subservient to their emotions and being driven more by information and legal authority will be the person who prevails in these types of situations. Now, will they go to the judge and say they wouldn't cooperate, and then they show up at midnight and kick the door in and take the kid when the judge gets pissed and signs the detention order? Maybe. But if they do, at least he will have made them do it the way that the Constitution provides, and he didn't just abandon his rights because he got intimidated by the cops. The smartest thing he did here was, one, and most importantly, to keep a physical barrier between you and the police so that you have all the options as far as what you are going to do. They're going to have to actually bust down the door or cross some line that they can't just explain away, unless they're in Cherokee County, Georgia, in order to come in and get you. But the second thing that he did that was really important was that he knew more than them about what they were allowed to do and what he was allowed to do, or at least he acted like he did. And then the third thing was that he just stood his ground and didn't let them push him around. And that's the only way that you can really beat these guys, is to be smarter, more resilient, and understand how things work a little bit better. Anyway, I thought this was a great example where we don't get very many to sort of see how a citizen should handle an encounter like cops at your door trying to gain entry to your house based on consent instead of doing the work to get a warrant. And this video seemed like it provided a good opportunity to have that conversation. So hopefully you guys got something from it. I'd like to invite you to come and check us out on all of the socials. I'll put this QR code up on the screen here. You can use your phone to scan it. That'll take you to the Linktree site where you can check out the YouTube channel, the Facebook, TikTok, Substack. You can join on a paid tier Substack if you want to, but that's only for people who want to support the channel monetarily. I don't put anything on these platforms that people have to pay for. If you don't want to follow us to other platforms, but you'd like to support monetarily, I'll leave my Venmo and PayPal links both here on the screen as well as in the description. Please remember to like and subscribe and leave a comment on the video. Check out some of the other videos on the channel and leave a comment on there as well. Until I see you again, take care. Always film your interactions with the police and keep your evidence to yourself.